I'm proud to say that today we have over 82 people joining us on Zoom, and we had over 30 viewers on Facebook. So thanks everybody for being here today. We're gonna, cross over right now and start answering questions. So it looks like we have a good number of questions here today. I'm seeing over 15 already, so awesome. So our first question is from a board member who is also a treasurer in your association. I am a recently elected board member of our association, and I'm the treasurer. I noticed that our management company was passing through to our homeowners an additional charge beyond the late charge for past due quarterly assessment. It's my understanding that the association is limited to charging a late charge under the Planned Communities Act of $15 or 10% of the assessment, whichever is greater. Any costs that we incur in the collection of past due assessments is a cost that the association needs to absorb. Is this correct? Great question. So what I would need to know to help you manage this question would be, what does the management contract say between the association and the management company? In a management contract, there's typically what we call an Exhibit A, and that outlines all of the different charges that a management company can charge as per their contract. And so I don't know if this might be like a rebilling fee that the management company is charging, or if it's a collection cost that maybe they're sending a letter and they're charging the owner for the collection cost. So I would probably need to know more information. Based upon what you're telling me, you're just saying they're passing through an additional charge. So if they're calling it a late fee and you're a planned community, you are limited under the law to the $15 or 10% of the assessment, whichever is greater. That is the maximum late fee you can charge in a planned community. If you're a condo, there is no such limitation, so I want to make sure I make that caveat known. If it's a collection charge for maybe sending out a reminder letter or something, that is okay under Arizona law. You can collect, collection charges of that nature, and attorney's fees would also be covered under that. You can lien for those. If it's a rebilling fee, assuming that they're sending out a letter and that's what the rebilling is regarding the violation, that's probably okay too. So I would just need to know more information. If it's called like an add-on late fee, that's not going to be okay under the law, because it appears that you've already maxed out what you can charge under the Planned Communities Act. Next question is from an owner. How do you deal with the board president who wants to hold executive sessions to talk about an owner behind their back? Not one of the 5 reasons given under the state statute. If you question the board president, she gets mad. Even if the owner points out the reason for holding the meeting is illegal, she wants to ignore the objection and hold the meeting anyways. What should be done? Okay, it's always hard when you're an owner and you're not on the board, and the board goes into executive session to discuss one of the 5 topics that they can talk about during executive session, which just quickly would be like advice from your attorney, any pending or contemplated litigation. Maybe you're talking about personal health or financial information about an owner in the association, independent contractor, or an employee of the association. Maybe talking about the job performance of or compensation of a vendor or an employee of the association. It's hard when you're the owner because you're not there, so you don't really know what they're talking about. So do we know for sure that they're talking about an owner behind their back? Well, you don't, because you're not there. Maybe you've got somebody who's leaking information, and that's a whole nother violation in and of itself. But a couple things. So how do we deal with this? Well, I think one suggestion would be make sure that your board is aware of the open meeting law and the different types of things that they can go into executive session to discuss. And a great thing to do would be to give them our cheat sheet on running a board meeting. It's called Board Meetings, and that outlines very specifically what are the procedures for going into executive session, what are the topics. So remind them, a friendly reminder that these are the topics that you're only allowed to discuss. And then also hold the board accountable. They should be putting on their notice of the executive session meeting which of the 5 topics they're discussing during executive session. And really, that's all you can do as an owner. You should consider running for the board. If you want to be more involved in, board actions and executive sessions, that's something that you can do. You can remind the board of their obligations, like I talked about. If you think that there are violations of the law going on, you can start a removal petition for your board and see if you have the support of the community. Next question. If our rules are silent on assembly, are we required to affirmatively publicize the right to assemble or establish a written policy? So this question is going to be on the new legislation, which is going to be going into effect 91 days after the legislative session ends. This is all very new because just last week, the law was signed by the governor. So, here's what I would recommend to associations. Don't overcorrect, okay? The reality of this is, I think that 99% of associations are not going to be having peaceful assembly by owners to discuss association issues. Maybe I'm wrong, but I think probably there's going to be very few associations that encounter this. So I think an overcorrection would be, passing rules now regarding how this is a new law, and now we need another rule on this. And I sometimes I scratch my head a little bit when I see, different companies putting out, you can buy the rules from us. Now there's a new law. It's like a cash cow, right? I mean, I'm not suggesting that approach here. We will, as a firm, be putting out rules for free on the artificial turf and on peaceful assembly. But I think you should take a wait and see approach and not overcorrect and start publicizing. If you're going to have, public assembly, here are the rules for it. And see if it's really something that's going to be an issue in your community. So peacefully assembling, it's already been happening in your association, right? People are talking at the pool. And I mean, we've seen over the years, maybe homeowner groups that are upset about something. Maybe they have their own little side meeting at the gazebo, and it hasn't been a big deal, okay? What could be a big deal is if, you're bringing in maybe a political candidate, like the law says, or a non-member guest, and it's a controversial issue. That's when you really need to be thinking about, okay, we need to be thinking about what rules we need in place so that if there is a large number of people in our common areas, that it's safe and that nobody gets injured, etc. Do I see that happening in a lot of associations? No. If you feel that this might happen in your association, that's the time to kick it in gear and to consider some rules that will keep in mind the safety and preservation of your common areas so things don't get damaged. Okay, so are you required to affirmatively publicize this right? No. The law says that it's the right. I'm sure there'll be plenty of newspaper articles and there'll be a lot of people discussing this. Do you have to establish a written policy? No. This is something that you can do if you think this is going to be an issue in your association. Okay, question number 4. How do you suggest we deal with homeowners wanting the HOA to provide a safety patrol to prevent theft or violence in an ungated community? It is my opinion that because we are not gated, there is no legal expectation of providing this service. It is also my opinion that it's the responsibility of each owner to take care of their own property. Homeowners should call the police if there is an issue on their own property or in the common areas. Okay, so I have a really good cheat sheet on limiting liability. It's called Theft and Prevention, How to Prevent Theft and Fraud. In the association, we also have another one on, let's see, so theft and fraud is going to be more like if stealing money from the association. I have another one on keeping the common areas safe and free from crime that I would recommend that you take a look at on our website. And that just gives tips that boards can do to make sure that they're keeping their common areas safe and free from crime. Okay, so you're kind of in a sticky wicket here because you've got homeowners who want a safety patrol. So my backup question is, do you have issues? Are you seeing, cars being broken into? Are you having assaults in your community? Is there something going on that is prompting the owners to want us to up our game and have a security patrol? And on our cheat sheet, we give some different suggestions, and we talk about an important case in Arizona called the Martinez versus Woodmar case. And in that case, it did involve an association that had a security patrol, and then they decided for financial reasons to eliminate the security patrol. And during this entire time, they had some issues with gang activity in their community. And so the bottom line in that case is associations do have a responsibility to keep common areas safe and free from crime. Now, whether or not that extends into paid safety patrol or not, I don't know. I don't know the facts. I don't know if you have the budget for that. But this cheat sheet that we have gives you some really great suggestions on what are some things that boards can do to make sure that their common areas are safe and free from crime. Maybe you start a block watch. And typically that's done by homeowners. So maybe if you are, serving on your board and your owners are asking for this, put them in touch with your local police precinct and start a block watch. Maybe you have to start publicizing to the residents about, hey, we've had some break-ins. Don't forget to close your garage at night. Don't forget to not leave valuable articles within view in your vehicle if it's parked in front of your property. Or maybe you have to take more serious steps where there's enough people upset about this that, hey, maybe we do need to have a security patrol be, coming through our community. So you have to look at it based on the facts and on a case-by-case basis, but I really encourage you as a board to look at our cheat sheet because there's a lot of things you can do that can limit the board's liability and also help provide safer common areas in your association. Okay, next question, number 5 is while supervising a vendor in our community, an owner who did not approve of the repairs being made pinned me against the wall and punched me. I have a restraining order against the owner due to 2 other displays of violence towards other board members. We are about to remove a small grass area in our community. Unfortunately, this common area that is going to be worked on is in front of this owner's unit, and I fear retribution as a result. How can I protect myself and perhaps the vendors who will be doing the work? Okay, a couple things. I think you're on the board based upon the way that this question is worded. Obviously, you have a really difficult owner, and if you already have an injunction prohibiting harassment against this owner, a court also agrees that this person is a difficult owner. So one thing that if I were advising your association, one thing that I would consider would be hiring a security guard or an off-duty police officer to help supervise this project that you're going to be doing adjacent to the owner's property. I would have really good communication with that owner so that they're aware that this work's being done. I would talk about it at an open board meeting, give that owner an opportunity to be heard if they're opposed to it or whatever. I mean, it doesn't mean you're going to change your mind. It's just making sure that they're aware this is what is happening and you have an opportunity to let us hear how you feel about it. If he can't come to the meeting because of the injunction, maybe he can appear by Zoom or he or she can appear by Zoom or maybe write a response. Having somebody, an off-duty police officer, is recommended. I also would notify the vendor of the situation so that when they are present, that they are aware of their surroundings and they know that, hey, this is going to be potentially something that could be difficult. I think these are all really good suggestions. And then the next question is just make sure that if you're removing this small grass area, make sure that the reason why you're doing it is legitimate and that's not in any way to get back at this owner or something like that, because we certainly don't want to do anything to fan a fire that's already raging. Okay, next question is from Facebook. So we are being made aware of a water crisis. How does this impact artificial grass? Well, I think what I would say is the new legislation this year, which prohibits associations from prohibiting artificial grass, is a direct result of lots of discussions throughout our state about the water crisis and some of the new mandates that are going to be imposed by state agencies regarding how water is used in associations in the future. So how does this impact it? I think we're seeing our state, making it known that associations will be prohibited from not allowing artificial grass in associations going forward. And I think we're already seeing a large amount of turf conversions from turf to desert landscaping. That's a very common thing that associations are doing, and there's some of them are getting grants from the different cities that they live in, which are 50-50 grants, where the association pays 50%, that maybe the city has a grant program where the city or agency within the city helps pay 50% of the project. So, I think these are all direct results of the ongoing water crisis in Arizona. And I think we can expect there's going to be more green legislation in the future to limit associations and other large landowners from using an excessive amount of water. Next question, number 7. During board member and owner meetings, can members make motions or second motions? So members that are not board members, can they make motions or second motions? No, they can't. If the board, wants to hear from the member about a topic, of course they can hear about it during the owner forum, or a member can make a comment before the board takes formal action, but only a board member can make a motion at a regular board meeting. Now, if we're at like an annual meeting, same strategy. So can an owner make a motion or second a motion at an owner meeting, such as like a meeting of the membership or like a removal meeting or an annual meeting? Owners can make comments, but a meeting of the membership is not a time to be making a motion or seconding a motion other than the approval of last year's meeting minutes. But, to like make a motion to increase the assessment rate at an annual meeting is not an appropriate motion. Okay, next question, number 8. You mentioned putting in or changing our CC&Rs length of time minimums on short-term rentals. Must this be done there, or can we change this through our rules and regulations? 99% of the time, that is something that will need to be in your CC&Rs, unless the language in your CC&Rs gives you the authority to pass minimum time rentals for short-term rentals or something like that. So we don't see that very often. But 99% of the time, this is going to need to be something that needs to be placed in your CC&Rs, and you'll have to follow the amendment procedure in your CC&Rs to do that. Question number 9. My community has major issues with our board of directors due to a number of incidents. Many of us would be interested in having an outside company manage the association and take it out of the board's hands. How can we do this when the board is the problem? Okay, so we've got a classic case of owners who are unhappy with how the board is running things, and they think that things could be better run by bringing in a management company. So really the decision maker on how to spend association money or whether or not to hire a management company is made by the board. And so I recommend that if you are unhappy with your board, that you consider running for the board so you can be a decision maker and make determinations of this nature. Another option would be to remove the board. If enough members in your community, are in favor of removing the board, the process to remove a board member from, office is outlined in our top 10 things you need to know about Arizona law cheat sheet. It's number 6 on the flip side of the cheat sheet, and that will give you an overview of the procedure. Remember that trumps your association's bylaws provisions on removal of directors. State law is controlling on that. So run for the board, think about removing your board, suggest to your board that having an outside company might make their jobs easier. Maybe the board, will listen if you, give that suggestion to them. Next question, number 10. Can you please provide some board meeting conduct rules? If you send me an email at bmulcahy@mulcahylawfirm.com, I can definitely give you some sample rules that you can implement in your association. But remember, every association is different. So if you're having problems, you're going to want to fine tune and tweak those to make sure that you're covering any potential issues that your association is facing. Okay, question number 11. The Arizona Supreme Court, in the recent case, considered CC&Rs as special contracts. Does a special contract mean anything to you, or is there a legal definition or clear guidance on what constitutes a special contract? I absolutely love this question because I thought it was very odd that the Supreme Court of Arizona also characterized CC&Rs as special contracts. Maybe they're doing it because the terms of the contract aren't negotiated by all parties because the restrictions in the contract, the CC&Rs run with the land, and when you fall in love with a house that has a deed restricted CC&R restricted community, you get what you get, right? Because the CC&Rs are already in place, and you're buying, the home or the unit in the association. But one thing to think about is, you had a choice to not buy that home, and under the disclosure laws, you got a copy of the CC&Rs before you purchased your unit or lot. So you did have a choice. You could choose not to buy the house, choose not to enter into the contract. Regardless, I agree that's a really great take. It's interesting that you picked up on those words because it's a contract nonetheless. And it is surprising to me that the Arizona Supreme Court feels that they can intervene in a private contractual relationship. And in some instances, that could be perceived as overreaching. So just my thoughts. Next question, number 12. We have always had a 30-day minimum rental in our CC&Rs, but the owner turned his inherited home into an Airbnb and is regularly renting it for the past month for weekends only. Sometimes there are loud parties. We had an attorney send him a violation notice. If it doesn't stop, do you recommend a lawsuit? Are courts backing HOAs? Will the owner have to pay our legal fees? So all really good questions. And this is from somebody on Facebook. So thanks for being here today. Okay, so if you have a minimum rental period in your CC&Rs and you have an owner that is leasing for less than the 30-day minimum rental period, which is in your CC&Rs, this is definitely actionable, meaning that if they don't stop doing it, you most definitely can file a lawsuit. It is very likely, if you have good evidence, that you're going to prevail in the lawsuit and you will be awarded your reasonable attorney's fees. So all of the facts that you're giving me here today prove that, yes, this does appear to be a good case if this owner doesn't stop violating the 30-day minimum rental period. One caveat I want to say is it's always hard to prove that these people are, renting, because they tell the tenant, don't tell anybody you're only here for the weekend, and, they maybe do a lease in writing for a whole month, but the person's really only there for 2 days, and then they say, oh, they broke the lease. I mean, there's all kinds of games on this. So you want to make sure that you have your evidence documented really well, and you can always subpoena the rental company for more information that can help prove. Probably in this case, this person is really going to have a difficult time defending this, so they might just start following the rule after you file a lawsuit. Okay, next question from a long-term client of mine who is now a homeowner from Facebook. So great to see you here today. If an owner designates a renter to be their representative in their absence in writing, does the board have to allow this person all the rights of an owner at board meetings? So yes, this brings into play the designated agent portion of the open meeting law in Arizona. So an owner can designate in writing a third party. It could be anybody. It could be a renter, it could be a family member that's not on the deed, to be their designated representative at a board meeting, or a designated representative at the annual meeting. Now, their rights at a board meeting would be that they can attend, listen, and participate just like a regular owner would. If they've got the piece of paper and they've given that to the association that's signed by the owner saying, Johnny Appleseed is my designated agent, that person then can come and attend, listen, and participate at a regular board meeting, just like the owner would. Now, if the owner's there too, only one of them can talk, right? You can't have, this is my designated agent, and I'm going to talk, and now my designated agent's going to talk. No, you can't do that. Only one of you could talk. The designated agent could also come to like your annual meeting or meeting of the membership, but they cannot vote. That right to vote cannot be given through that designated agent form. It also cannot be given through a power of attorney, surprisingly. only the record owner of the lot or unit can vote at an owner's meeting. Now, the designated agent could come to the annual meeting, attend, and make a comment, but they would not be able to vote. Okay, next question. Suggestions for dealing with homeowners who several times a year get annoyed with a neighbor because of parking. The neighbor may have 4 to 6 cars parked in front of their house from about 9 to 5 daily for a week. The homeowners just don't like the cars being parked in the street. No driveways are being blocked, etc. They have been told time and time again, no rules are being violated. Yet every time it happens, they send many, many, many complaints to the property management company and to the members of the board. This has been going on for years, all caps. Okay, so let's talk a little bit about this. So the first thing that I would say, just objectively looking at this, is what do your documents say about parking? You know, your CC&Rs, does it say that they can park on the streets? Does it say that owners must park their vehicles in their driveways? Can guests come and park on the streets? Is it only during the day? Can they do overnight street parking? All these are questions I don't know the answer to. And so I guess I'm going to have to generalize here, but assuming that they have the right to park in the street and that no CC&Rs are being violated. You said no rules, but I also would say maybe no CC&Rs are being violated on this. What I would recommend to the owner that's unglued about the neighbor and parking their vehicles is say, hey, this is a neighbor-to-neighbor dispute. Try to talk about it with your neighbor. Maybe consider private mediation. Express to them that you don't like this when they do this and see if you can work it out yourselves, because this isn't our issue, because it is not in violation of our CC&Rs. You may want to check in with your city, town, or municipality to see if they have any thoughts on this, their code enforcement department. And if the owner that's complaining continues to complain and this is going nowhere because the CC&Rs allow what the other owner is doing, maybe it's time to escalate it to your attorney and say, please stop contacting us on this. We've given you the path to resolve this with your neighbor. We hope that you can resolve it, but please stop contacting us on this. And any future, communications with the association on this need to go to the attorney, because now it's crossed over to the point of harassment where you're constantly contacting us on this. Okay, question number 14. And just to give you a little question check, we only have 18 questions. So we have, 4 more questions. The next question is, we have a very difficult board president who makes unilateral decisions, some unlawful according to Arizona statute. She also personally attacks homeowners in meetings when she is presented with statute. She is censuring our homeowners on our website. It is a homeowner website, not a board website. She wants nothing negative said about her actions. What is the best course of action? Ooh, this is difficult. Okay, a couple things. So a board president should not be making unilateral decisions. So one board member doesn't make decisions for the entire board. A majority of the board makes decisions. Now, a majority of the board can delegate. We're asking the president to meet with the vendor and to select, what type of ground cover we're going to use or something like that. You can do that as a board. You can delegate that responsibility to, one board member. But the board member shouldn't be, an oligarch making all the decisions unilaterally. That's something that's not good, okay? Personally attacking homeowners when homeowners provide, evidence of potential violations of the law. That kind of goes both ways. I'm not going to lie to you, because sometimes we've got, personal attacks, first of all, should never be happening. Okay. Sometimes you've got like a Hatfields and McCoy situation between owners and the board, and I don't like seeing that. Remember, the board needs to be the bigger person, so to speak, and they're running the business. They need to treat it like a business, be respectful of the owners. And in return, the owners also need to be respectful of the board. And so, throwing a paper airplane at the board during the meeting saying you're violating the open meeting law or something, that may not be the best way to get your point across. So be respectful in how you notify the board that you think there's a problem. And in return, the board should be treating all owners, professionally and respectfully. Using the website to call out people, I never think that's a good idea. We've had questions like that in the past where should we put the names of the owners that have violations on their lot or that aren't paying their assessments on our website? I really don't recommend doing that. It doesn't work because usually those people aren't even going to the website. They don't care. And it's just potentially putting you in line of liability in the event that you're wrong and somebody sees it and potentially sues the association for defaming them. So we don't think that's a good policy. And sometimes it's hard to take criticism when you're serving on the board. So, apparently this board president doesn't want anything negative said about our actions, but constructive feedback can sometimes be helpful for everybody. So I would encourage, all boards to listen when people are upset about something and try to find some common ground and take a look in the mirror and see if maybe your actions need to be adjusted. Okay, so if you do all this and it's still not working, what's your best course of action? As a homeowner, if you have a number of other like-minded people, you could try to remove the board president from office. You could hire an attorney to send a letter to the board regarding some of these issues. You could run for the board yourself. You can move. You have lots of different choices on how you handle this. Okay, last 3 questions regarding House Bill 2158. Does this allow sun-up to sunset solicitation, door-to-door, in a condo association of individuals promoting state and federal candidates? Can a gated community refuse entrance to political petitioners? So, no, I do not. It's my opinion that this new House Bill 2158 doesn't allow for solicitation, promoting state and federal candidates. It does allow peaceful assembly. Now, that doesn't say solicitation. It just allows an assembly. Can a gated community refuse entrance to political petitioners? You can have no trespassing signs, no solicitation signs, and if it's gated, you can refuse access. Obviously, if somebody wants to have a peaceful assembly and they invite one non-owner, an owner can invite one non-owner under the new statute to talk about an issue that may directly affect your association, they certainly would have the right to do that. But solicitation and door-to-door solicitation is not something that this new law allows for. Okay, our board sometimes conducts what they call work-study meetings between regular meetings, free of our property manager and the formality of regular meetings and the open meeting law. Are these legal if we are just needing more time on more difficult agenda items and working through board questions on topics? Sometimes the regular meetings don't allow for us time to work on these things. So anytime you have a quorum of the board discussing association business, even if it's called a work study and even if you're not making decisions, if you're quorum of the board discussing association business, that is an open meeting and you must follow the Arizona open meeting laws. And so you would have to follow the formality of the Arizona open meeting law. Some ways around this is to have less than a quorum meet to prep for issues. If you have a more difficult agenda item, have less than a quorum of the board meet, and that would not be a violation of the open meeting law. Okay, last question. Is there a time when the entire CC&Rs would be entirely rewritten? So, I'm never a proponent of taking the CC&Rs and throwing them in a trash can and starting over. I think every association has different needs. Every association has different common areas. So there's no one fits all CC&R set that's out there that everybody should just adopt, because every association is different in terms of what amenities they have, how large they are, what type of maintenance responsibilities they have, etc. And so what we would recommend as a good practice pointer or a best practices type thing would be about every decade, your association should be doing just a general update of your CC&Rs to bring it in compliance with any changes that may have occurred in Arizona law, or to, update it, clean it up a little bit, your CC&Rs, so that they stay with the times and so that they, are a living, breathing, useful document for your community as your community evolves and as the legislature writes new laws that apply to associations. So we have a great cheat sheet on 5-step plan for amending CC&Rs that you may want to take a look at, which would be helpful in giving the reasons why you amend CC&Rs and giving you a successful 5-step plan that could help your community if you're thinking about amending your CC&R. Over 82 people with us here on Zoom, over 30 viewers on Facebook Live. What a great turnout. So happy to be partnering with these numerous different cities to provide this great learning opportunity and a free place where you can come and ask questions. I look forward to our future classes. As you know, we have these neighborhood services, Virtual HOA Condo Academy once a month. So it's always the third Tuesday each month. So our next one's going to be the third Tuesday in May. We also have some additional special classes coming up. Last week, I taught a class for the city of Chandler, and I'm going to be teaching a few more with the city of Chandler, and those are actually in person. So my next one is going to be next Wednesday evening. And for those of you who have registered and are participating in the Chandler HOA Academy, I'll see you in person next Wednesday. Otherwise, I'm going to see all of you virtually, or our firm's going to be seeing all of you virtually. Don't forget, we've got our May 6th virtual First Friday free call-in. I have Hayden DiLorenzo from our firm that's going to be handling that particular one for our firm. So I know you're going to enjoy her presentation and also her answers to your questions. And then, of course, we urge you to join us next month for our Virtual HOA Condo Academy class number 5. That's scheduled on Tuesday, May 17th at 11 a.m. Next month's topic is how can we effectively work with management company and vendors? And we're going to have our Q&A session at the end where you can ask questions at no charge. So just wanted to thank you again for being here today. I hope you'll be joining us in the future for our future virtual classes. I'd also just like to thank again the different cities that we're partnering with for these virtual classes. We're very appreciative of the opportunity to work with you as a team member to provide free education for the different residents in the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. So thanks for being here today. Look forward to future classes with you, and I hope everybody has a great rest of the week. Take care.